Welcome to the Deep Dive. This is where we plunge into a stack of your source material, pull out the essential insights, and help you get well-informed, quickly, and efficiently.
We're your guides, kind of cutting through the noise to get straight to the knowledge you need.
Exactly. And today we're continuing a series focused on a truly foundational text in patent procedure, the Manual of Patent Examining Procedure, or MPP.
Specifically, we're spending time with Chapter 1800. This chapter lays out the procedures and rules for international patent applications filed under the Patent Cooperation Treaty, the PCT. You know, the global system for simplifying multi-country patent filings.
And our specific target within Chapter 1800 today is MPP, Section 1821, titled The Request.
Right. So our mission for this deep dive is to really understand precisely what this document is, its key formal requirements, and maybe why paying close attention to those details is absolutely critical in the international patent process.
And our source material today comes directly from excerpts of the MPP itself.
That's right. Straight from the source.
Okay, let's jump right in. What is the request in the PCT system? Is it just like asking for a patent internationally?
Not quite that simple. Think of it more like the official starting pistol. It's the document that formally kicks off your international patent application under the PCT.
Okay.
And it's definitely not just a generic letter or petition. The sources really emphasize it's a highly standardized, rule-driven document. It's designed for a very specific purpose and has specific legal consequences.
Standardized, meaning it has to look a certain way.
Yeah.
So I mentioned a form, PCTRO 101.
That's exactly right. You generally must use that specific form, PCTRO 101, or more commonly now, a computer-generated equivalent. Yeah. But that equivalent has to strictly follow the PCT administrative instructions.
So consistency is key.
Absolutely. That standardization is crucial for the PCT system to actually function smoothly across, all the different receiving offices and countries involved.
Okay, so how do applicants usually prepare this form these days? Are people still filling out paper copies?
Well, the paper form does exist. You can download it from WIPO's website. That's the World Intellectual Property Organization, the UN agency running the PCT. But honestly, the modern system heavily favors electronic filing.
Technology takes over.
Pretty much. The web-based ePCT system has largely replaced the older PCT-safe software that some might remember.
ePCT. And I assume there are good reasons for that shift. Benefits to using the electronic system.
Oh, significant ones, according to the sources. The ePCT system, for example, has built-in validation checks.
Validation, so it tells you if you've made a mistake.
Yeah, it helps catch potential errors in your data before you even submit it. That's huge. Plus, it generates a ready-to-submit zip file, which bundles up your request form, and usually a fee calculation sheet, too.
That validation sounds incredibly useful. Could save a lot of potential headaches down the line, I imagine.
Definitely. And there's another big plus cost.
Yeah. How so?
Well, using ePCT and filing electronically, especially through national or regional portals like the USPTO's own patent filing system, EFS Web, that's the electronic filing system for the U.S. Patent and Trademark Office, often makes the application eligible for certain fee reductions.
So a direct financial incentive.
Exactly. So validation, convenience with the zip file, and potential cost savings. Electronic filing via ePCT is generally the way to go.
Makes sense. But even with these helpful electronic tools, I suppose accuracy is still absolutely vital. The system can't catch everything.
Absolutely paramount. The sources give a strong reminder here. Accurate data entry when using any electronic interface, ePCT or EFS Web, is critical. While validation helps, garbage in can still potentially mean garbage out, leading to delays or worse, incorrect processing later on.
Right. So double check everything. Okay, yeah. We know what the request is, roughly how it's prepared. What specific core information absolutely must be included in this document?
There are a few essentials you absolutely have to nail down. First, the title of your invention. Then, clear identification of the applicant or applicants who's seeking the patent. Also, identification of any agent or representative you've appointed, like a patent attorney. And crucially, the designation of at least one PCT contracting state.
Okay, that last one designation, identifying which countries you want protection in. This is where the PCT gets really powerful, isn't it? Something about automatic designation.
It really is. This is covered by PCT Rule 4.9, and it's a cornerstone of the whole system. It's quite remarkable, actually. By simply filing the request, you automatically designate all PCT contracting states that are party to the treaty as of your international filing date.
Wow. Wait, so you don't have to sit there and tick boxes for like 150 countries. Just filing the form covers basically the PCT world by default.
That's precisely the default effect. It's an opt-out system rather than opt-in for designations.
That's huge.
It is. And this automatic designation covers all available types of protection within those states, too. So whether you might later want a national patent in, say, Canada, or maybe a regional patent, like a European patent handled by the EPO, the initial designation covers those possibilities.
So it buys you time and keeps your options wide open across the globe, at least initially, without massive upfront paperwork.
Exactly. It preserves your options in a huge number of territories without the cost and effort of individually listing them all at the start.
That seems like a massive benefit. Are there any exceptions? Any countries where this automatic designation doesn't happen?
Yes, there are some specific nuances and exceptions. Some countries, maybe due to their own national laws or specific reservations they made when joining the PCT, might not be automatically designated in all cases. Or certain types of protection within them might be excluded from the automatic effect. The sources mention Germany, Japan, and the Republic of Korea as examples where specific national circumstances or reservations could modify this default designation. So you can't just assume 100% coverage without checking for these rare exceptions if a specific country is critical.
Right. So the general rule is you're in everywhere, but be aware of potential carve-outs for certain places. Now, what if you actively don't want to designate a particular country? Say you've already got a national patent application filed there, and maybe designating it again via the PCT could cause legal problems, perhaps invalidate that earlier filing.
That's a really important scenario, and yes, you need to be careful. If you intend to exclude a specific state from designation, withdraw the designation, essentially for a valid reason like that, the exclusion must be explicitly stated in the request itself.
You have to specifically say, I don't want this country.
Yes, but it's not just a matter of preference. This exclusion is only possible if it's permitted under specific PCT provisions, like Rule 4.9b. And critically, that country must have properly notified WIPO's International Bureau, the IB, that it allows such exclusions under those circumstances.
Ah, so it depends on the country's own rules, too.
Exactly. It's not something you can just decide to do arbitrarily. It has to be legally supportable based on the PCT rules and that specific country's notified position.
Okay, so automatic designation is a huge plus, but you need to understand the details, the potential exceptions, and the very specific process for excluding a country if needed and allowed. Makes sense. Let's shift to the people involved. The MPEP seems very particular about how you identify applicants and inventors.
Oh, extremely particular, and for good reason. Accuracy in identifying the legal entities and individuals involved is absolutely fundamental for processing the application correctly and for the ultimate legal validity of any patent granted.
So names and addresses need to be spot on.
Spot on and in the right format. The sources detail specific formatting rules for names. If it's a natural person, an individual inventor, or applicant, the family name must be written first, and in capital letters, followed by their given names.
So like Smith, Jane? Not Jane Smith.
Precisely. And if the applicant is a legal entity like a company or university, you must use their full official designation. No abbreviations unless they're part of the official name.
Okay. And addresses.
Yeah.
Just the usual mailing address.
It needs to be complete and effectively postal ready. That means including the country, obviously, but also any necessary administrative units like state or province, city, street, house number if applicable, and the postal code. The goal is to ensure official communications from the receiving office, or WIPO, actually reach the intended recipient without issue.
Makes sense.
Yeah.
Now, you mentioned the applicant. We usually think of the inventor as the applicant, but can it be someone else?
Yes, especially under current U.S. law, which aligns with PC2 practice. For applications filed on or after September 16, 2012, the rules are broader. The sources reference both MPP Chapter 1800 and the U.S. Code of Federal Regulations, specifically 37 CFR.
Okay, so who qualifies?
It can be the inventor, or if there are multiple, all the joint inventors together. It can also be a legal representative acting for an inventor who is deceased or legally incapacitated. That's under 37 CFR 1.43.
Oh.
Or, quite commonly, it can be an assignee, the company or person the inventor has transferred their rights to. It could also be someone the inventor is obligated to assign to, or even a person who can demonstrate a sufficient proprietary interest in the invention, according to 37 CFR 1.46.
That list is definitely broader than just the inventor. If a company, the assignee, is listed as the applicant, can they just start making decisions about the application?
Not always automatically. The sources note that if an assignee is listed as the applicant, but they weren't the original filer, maybe the inventor filed initially, the assignee generally needs to formally establish their ownership within the application records before they can take certain actions, like appointing a new agent or making amendments.
Ah, so there's a step to prove ownership usually. What about the representatives, the patent attorneys or agents managing the application?
They play a crucial role, of course, and they need to be clearly identified in the request if one is appointed. The sources mention something useful here: customer numbers.
Customer numbers.
Yeah, particularly relevant for the US PTO. It's a system where a law firm or group of registered practitioners can be associated with a single customer number. Naming that number in the request can effectively designate that entire group to act as the representative, which is often easier than listing every single attorney individually.
Streamlines things a bit.
It does. And naturally, the request also requires a clear correspondence address. This is vital. It's the address where all official notifications regarding the international application will be sent. It could be the agent's address or the applicant's.
Got it. Now, are there any extra requirements if the application specifically designates the United States? Anything unique for the U.S.?
Yes, a couple of key points for U.S. designations. First, the inventor's name must be included in the request, even if an assignee, like a company, is listed as the applicant.
Okay, inventor name is mandatory for the U.S.
Correct. And second, you need to properly include details of any relevant priority claims if your PCT application is based on or claims priority from an earlier U.S. national application or even a previous international application that designated the U.S.
Priority claims, that's when you're referencing an earlier filed application to get the benefit of its filing date for the shared subject matter, right?
Exactly that. The sources briefly touch on the general requirements. You typically need to identify the prior application number, its filing date, the country or office where it was filed, like the USPTO, and sometimes the relationship, like if it's a continuation, divisional, or a CIP, continuation in part, of the earlier case.
How is that information usually provided?
Often this detailed priority information is provided in a separate document called an application data sheet, or ADS, particularly for U.S. practice, or sometimes it can be included within the patent specification itself. The MPP also mentions that for U.S. designations, applicants may include a specific declaration under PCT Rule 4.17 directly in the request. Doing so can sometimes help streamline certain procedural aspects later when the application enters the U.S. national phase.
It really sounds like every single box, every piece of information in this request document is there for a very specific reason, and getting even small details wrong could cause significant problems.
Precision is absolutely non-negotiable. The MPP and the PCT rules are very clear on this. The request must strictly comply with PCT rules 4.1 through 4.17.
Strictly comply.
Yes, and it cannot contain any material that isn't specifically authorized by the form or the rules. If you try to include, say, extra arguments or descriptions not asked for, the receiving office is simply instructed to delete that extraneous content.
So no room for creativity. You can't attach a cover letter explaining why your invention is so brilliant.
Definitely not as part of the formal request itself. Any supplemental information that is legitimately required by the rules but maybe doesn't fit neatly into one of the standard boxes, perhaps continuing information from another box, can potentially be added. But it has to go in a designated supplemental box, and even then, it needs clear labeling, like continuation of box no 4, so the officials know exactly what it relates to.
Okay, very structured. Any other tricky formatting things to watch out for in the request?
One small detail is dates. Dates appearing in the request often need to follow a specific dual format for clarity across different conventions, something like 20 March 2020 followed by 20/03/2020. Check the specific instructions, but be aware of date formatting.
Right. And stepping back just a bit, you mentioned earlier the request is part of a larger application package. The MPP excerpts also touch on other formatting rules applying to the whole international application, not just the request form itself.
That's correct. These are general formalities for the application package. For instance, a common one is that color drawings are generally not permitted in international applications filed under the PCT. They usually need to be black and white line drawings.
No color pictures. Okay.
And another big one, especially for biotech conventions, if your application includes genetic sequence information, there are very specific formatting rules. For applications filed on or after July 1st, 2022, those sequence listings must be provided in the official WIPO standard ST.26 format, which uses XML.
ST.26 XML. Sounds technical.
It is. It's a specific data standard mandated for sequence listings now. So these are details outside the request form itself, but absolutely part of the overall compliance picture for the international application.
Okay. And one final point on formalities that was highlighted. What about considerations based on where you're filing from? Specifically, the need for foreign filing licenses for U.S. applicants.
Ah, yes, that's a critical piece of the puzzle, particularly for applicants based in the United States. Before you even think about filing a PCT application that will designate foreign countries, you have to be mindful of U.S. foreign filing restrictions.
Meaning you might need permission from the U.S. government first.
Exactly. Depending on the subject matter of the invention and where it was made, U.S. law may require you to obtain a foreign filing license from the USPTO before you file that PCT application internationally. This is covered in MPEP Section 1832. It's a distinct requirement from the PCT rules themselves, but absolutely essential for U.S. applicants to clear before submitting their request to a receiving office, including the USPTO acting as a receiving office. Failure to do so can have serious consequences.
All right, so get the license first if needed, then file a PCT request. Good point. Okay, this is a lot of detail. Maybe walking through a brief example could help tie it all together. The sources gave one. A U.S. applicant wanting PCT coverage for Europe, Japan, and the U.S.
Okay, yeah, let's use that. So our applicant is based in the U.S., they have an invention, and they want patent protection in those key regions. Europe, probably via the European Patent Office, Japan, and domestically in the U.S. They decide the PCT route is efficient.
Makes sense. So they'd likely start
By preparing their request form, most likely using the WIPO ePCT platform we talked about.
taking advantage of that built-in validation feature.
Precisely. They'd carefully fill in the invention title, their own applicant details, making sure their name is formatted correctly, family name in caps if they're an individual, perhaps identify their patent agent using a customer number. Critically, by simply filing this request, they automatically get designation for all PCT states, which naturally includes Europe as a region, Japan, and the U.S. They don't need to list them individually unless there's an exception.
And for the U.S. part.
They'd need to make sure the inventor's name is explicitly included as required for U.S. designations, and they'd add the necessary details for any priority claims if they're linking back to an earlier U.S. application.
Then, once the form is validated and complete in ePCT,
It generates that zip file. They'd then take that file and submit it electronically to the USPTO, which can act as a PCT receiving office for U.S. applicant.
okay, and the benefits they get right away.
Well, they likely qualify for that fee reduction because they used ePCT and filed electronically. And most importantly, they've secured that broad automatic designation for Europe, Japan, the U.S., and potentially over 150 other territories, preserving their right to seek protection there later on during the national phase entry stage.
Great. Now, let's add that complexity we discussed. What if, in that same example, our U.S. applicant had already filed a national application directly in Japan a year ago, and they were worried that the automatic PCT designation for Japan might somehow conflict with or invalidate that prior Japanese filing?
Okay, the exclusion scenario. This is where they'd need to be very careful and follow the rules precisely. If they have a valid legal reason under PCT Rule 4.9b to exclude Japan, and assuming Japan has notified WIPO that it allows such exclusions under those specific circumstances.
Made assumptions there.
Yes. Then, within the request form itself, likely in the supplemental box with clear labeling, they would have to explicitly state the withdrawal of the designation for Japan, potentially referencing the specific rule allowing it. It's not just unchecking a box, it's an active, formal exclusion statement that needs a proper legal basis.
So it really highlights that even with a seemingly user-friendly system like ePCT, a deep understanding of these detailed rules, automatic designation, the specific conditions and procedures for excluding a state, the strict formatting for names, dates, everything is absolutely essential.
It truly is. You can't just skim the surface. The request might look like just another administrative form, but it's the legal gateway. It's the document that sets the entire international patent process in motion. Getting it right, adhering strictly to these MPP guidelines and PCT rules right from the very beginning sets a strong and proper foundation for the entire global patent journey.
Okay, before we wrap up, the standard disclaimer. This summary of the MPP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, please consult the official MPP, a qualified instructor, or a registered patent practitioner.
And we also want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series. His work made these deep dives possible.
Absolutely. So we've done a pretty deep dive today into MPP Section 1821, and the request, clearly a critical and very rule-driven first step in the PCT international process.
Yeah, we've seen it's far from a simple form. It's a highly standardized document demanding real precision in every detail, names, addresses, dates, leveraging that powerful automatic designation, but also knowing exactly when and how you might need to explicitly exclude a state, if permissible.
And understanding these requirements isn't just, bureaucratic box ticking.
Yeah.
It's about setting the stage correctly for potentially protecting your invention globally, making sure you actually benefit from the PCT system's efficiencies while avoiding some potentially very costly errors early on.
Definitely. Which leads to maybe a final thought to leave you with. Consider how much potential future value the possibility of patent rights in dozens, maybe over 100 countries, is essentially initiated and hinges upon this single, highly formalized document. A document that, on the surface, seems like just a collection of names, dates, and checkboxes. What does the immense weight placed on the precision of this initial document tell us about the fundamental nature of international intellectual property law and how critical seemingly small details and strict rule adherence become when operating on a global stage?
A lot to think about, indeed. Thanks for diving deep with us today.